Child Support Law number 3 of 10 in the series, the Family Support Act of 1988, marks the moment that child support moved from manual court orders to automation. This law did not just tighten the system, it built the machinery that still runs it today. If you missed the first 2 child support law videos in this series on Title 4D of 1975 and the Bradley Amendment of 1986, be sure to go back and watch those for a little bit of context. I'll put those links in a pinned comment for you. Because after the Bradley Amendment made child support debt permanent, Congress wanted to make sure that no one would ever fall behind again. So they built a law to track, record, and collect every support payment through mandatory automation. And that's where we pick up today with the Family Support Act of 1988. The act was signed by President Ronald Reagan as his administration's final push to strengthen Title 4D enforcement. It required every state to implement automated child support tracking systems to withhold wages and for states to have guidelines for support calculations. This was the law that brought computers into family court, turning support enforcement into data. So today I'm going to show how and why this law quietly shifted power from judges to software and from families to the state, creating the modern bureaucracy that now runs child support like a collection agency. Once the Bradley Amendment locked in child support arrears as permanent judgments that cannot be reduced or changed, Congress moved to the next logical step, preventing late or non-payments before they could even form. That meant removing human discretion and replacing it with automatic systems. So the Family Support Act of 1988 was sold as a way to help children get consistent support. But in practice, it created an infrastructure for permanent collection networks. The law mandated that each state develop a digital, central automated case registry, and they used it to track payments, orders, and arrears. And it required immediate income withholding, meaning that child support would be taken from a father's paycheck before he even saw it. It also demanded that states establish formal guidelines for calculating support based on income. So the amount was no longer left to a judge's discretion or the details of a father's financial or employment situation. This standardization was marketed as fair, but it also removed flexibility for fathers whose circumstances did not fit the support calculation formula. And I think it's important to understand that the late 1980s were a time of technological optimism and political toughness. So Reagan's America was embracing computer databases and federal oversight in everything from tax collection to law enforcement. And within that climate, automated child support payments were portrayed as a moral and technological win, a way to make fathers accountable through data and networked computers. But for men and fathers, it marked a critical loss of their own personal and parental agency. Because once a support order was entered, the machine took over. There was no pause button, there was no appeal to circumstance, and no room for negotiation. By the way, if you're new here, I'm Todd. I'm a psychologist and an author who supports men in life and relationships, and I expose many of the larger issues that men face today. If this is the kind of deep commentary that you want more of, be sure to subscribe. Let's see if we can get to 1,000 subscribers by the end of the year and help get these messages to more men who need them. So the Family Support Act of 1988 also required states to improve paternity establishment programs and to create education and job training services for parents on public assistance, though those provisions were largely underfunded and largely ineffective. In theory, it was meant to help non-custodial fathers earn enough to pay their mandated support. But in reality, those programs were minimal compared to the massive investments that were made to track and to enforce the new infrastructure. The money flowed into systems that collected, not to services that prevented the need for collection. For mothers, the Family Support Act was presented as a guarantee of support payments. It was a promise that the government would make sure that support arrived on time and at all. For children, it was framed as security. But for fathers, it cemented a shift from participant to debtor. Support was no longer something that men paid voluntarily as a responsible parent. It was something that was deducted from paychecks as a liability. Essentially, the act turned child support into a payroll function, and the long-term impact has been profound, because the Family Support Act laid the groundwork for several more laws that followed throughout the 1990s, which are coming up in subsequent videos in this series. And it set the precedent that child support enforcement was not a courtroom matter, but a data management process. It also taught states that more automation meant more collection rates, along with increased federal reimbursement payments to the states under Title 4D. For fathers today, the residual of this law is everywhere. Every automatic deduction, tax intercept, and license suspension system is rooted in this Family Support Act and its push for automation. It was the bridge between court orders and the digital state, and it took the personal out of parenthood and replaced it with code. So while Title 4D created the funding incentive and the Bradley Amendment made debt permanent, the Family Support Act of 1988 built the machine that runs it all. So let me know your thoughts or experience with automated tracking and support collections, and be sure to come back soon, because next I'll expose how the 1992 Child Support Recovery Act turned late support payments into a federal crime punishable by incarceration.